Welcome back. With us now is Scott Peatross. We were talking about probate law. Scott, before the break we were discussing real property and how it's treated in probate and when it does come in and when it doesn't come in. And we've mainly focused, I think, on testate estates, estates that had wills. Now the other variety, if somebody dies without a will, how does that process work?
One misconception that I see sometimes is people think that probate court is only for estates where you didn't have a will, or sometimes people think, well, it's only for estates where you do have a will. And the truth is that the probate process is necessary regardless of whether or not there's a will. And as I said earlier, the idea is just to provide a forum where a person's affairs can be wrapped up in an orderly way under the court supervision. The intestate process is different, obviously, because there's no will, and that's what that means. Intestate is that there's not a will. The process is also different because in an intestate estate, you don't have a will that says, I name my son so-and-so to serve as my executor. In that case, the court has to choose who will serve. It's called an administrator in an intestate situation. Under Tennessee law, there's a priority of people to be considered, and there are occasions, and I serve as a public administrator, and there are occasions where there's a lot of contentiousness among family members, and in those occasions sometimes I'll be appointed or some other neutral person will be appointed to serve as the administrator of the estate.
Now, in a situation in which the heirs at law are just minor children and they're being left whatever their parents had there, how does that process work? Because I think that may get us into the guardianship stuff.
Right. If it's a significant amount of money, then the court will need to appoint a guardian for each minor, and usually that's a parent or both of the parents. If it's under a certain amount, and I think the amount currently, it was increased recently, is $20,000, then the court has the ability to direct that the money simply be turned over to either the parent or the person that the minor resides with to be used for their benefit without having to go through a formal guardianship. And it's a guardianship, and just logistically is started the way most probate cases are, in that a petition's filed with the court asking that a guardian be appointed and letting the court know that there's some property out there that needs to be managed by a guardian. Then the court will appoint the guardian, and then the guardian's responsible for holding that money until the child turns 18, although sometimes the court will allow some of the money to be used for the guardian support.
Okay. And then another situation that I've seen is where we have two spouses. One spouse has dementia or something of that nature, and basically their caretaker, who is their spouse, passes away first, and then they're left with the estate and whatnot, but they're not competent to handle that. So in that situation, what happens?
I guess you're alluding to a conservatorship.
Yeah.
And we see, I think, conservatorship cases more and more often as the population ages. And when people, for whatever reason, are, the law says disabled, unable to handle their affairs for some reason, then the probate court, if a petition is filed asking for a conservator to be appointed, the probate court will assign a guardian ad litem to the case, who's a lawyer that will investigate the facts and determine if the person is disabled, and if so, who should serve as that person's conservator. And if the person is disabled, the court will appoint a conservator, who's typically a family member, one of the children, or a spouse of the disabled person. and the conservator is responsible for managing that person's property and making decisions for them. The court's order that initially appoints a conservator will specifically list what rights are transferred from the disabled person to the conservator. And the courts are careful, as the law requires them to remove as few rights as possible, the minimum necessary to protect the disabled person. And it may just be that they remove the right to enter contracts and sign checks and things like that, or make medical decisions, but they'll retain whatever other rights they have.
Yeah, and we've probably got some viewers out there that are sitting there going, well, wait a minute, can my kids just go in and get this done without a doctor saying that I'm incompetent?
You've got to have some expert testimony to prove to the court that the person is disabled and needs the court's protection. And the courts are very careful because it's a big deal to remove someone's rights and invest them in another person. And the law requires the courts to be very, very careful about that, and the courts are. To even file the petition, you typically need to have a doctor's affidavit, a sworn affidavit, to even proceed beyond that point.
Okay. Our time is up for this edition of Legalese. I'd like to thank our guest for taking time out of his busy schedule and sharing his thoughts and insights. If you would like more information about Legalese or any other program on GHS TV, please refer to our website at www.ghstv.org. Thank you for joining us today, and be sure to join us next month for more discussion on legal topics. Until then, I'm Vince Perryman. Thank you for watching.